The thing I like about that is that there's some people that think that I'm running some kind of cult in the litigation center, so when there's chanting like that, it actually feeds into that notion. Today we're talking about objections and responses at trial. So one of the things that's often disconnected in your legal studies is you all take evidence, and ideally you take evidence before you get into trial advocacy type courses or skills type courses. And inevitably in those trial advocacy or skills courses, you're forced to use evidence, object under the rules of evidence, respond with evidentiary responses to objections, and there's a disconnect. You learned it at one point, you understood the case, you understood the topic, but the idea of taking that understanding into the courtroom, using it as it relates to when do I object, using it as it relates to how do I best respond. And one of the things I'm going to talk about today, keeping up that air of the lights are on while you're in the courtroom. We talk about in trial advocacy, and hopefully by now you've heard in your sections of trial advocacy, that when you are in the middle of the well of the courtroom, you're in this odd environment where people from the public, people from the DMV, people from the BART station are watching you while you do your job. They're watching you on trial. And they do watch you and look what you wear and see how you act and see how you interact with opposing counsel, with the court reporter, and with the judge certainly. And they're taking notes, taking mental notes of all of it. And it's funny how when we talk to them in a jury address, we're certainly cognizant of that. That's when we put on our best self. Good morning, ladies and gentlemen of the jury. May it please the court. And we sound this way and we talk to them. And if we've worked on it for a few weeks now in your witness examinations, you're also cognizant that you have this audience and that they're involved in this discussion. Even though you're asking questions of a witness, you coach that witness to give the responses to the jury. And you're aware that they're there, you're aware that they're listening. Sometimes, as it relates to this disconnect, as it relates to objections and responses, and overall just the rules of evidence as they make their way into the courtroom, sometimes that awareness of that the jury's watching or that they're still judging drops off. Sometimes we lose sight of the fact that when we object, how we object, our face when we're preparing to respond. I know those in my class have seen this before, and they've seen it not only from me demonstrating it, but they've seen it from their own exercises. You're asking questions, you're mentally thinking of what's my next question that I ask for this witness? Oh, that was a pretty good answer. What's my next question for this witness? Oh, that wasn't quite the answer I was looking for. I have to ask a follow-up question. And then out of nowhere, you have objection. And you're thrust into an entirely different drill, an entirely different exercise that you have to detach from the witness examination, detach from the question and answer, and now go into this evidence drill. Now, look back on your time in evidence. What was that objection? What was the question I just asked? What was the rule implicated? Do I have a response under the rules? And you can see sometimes how our faces reflect that we are all of a sudden in some kind of different exercise. It turns into this. And it turns into what just happened and where am I? And instead, what we want to try to focus on today in this talk is actually making an opportunity out of objections. Seizing the opportunity of responding to objections if you are the proponent and you are the one that's asking the questions. So let's look through this. I always talk about the rules of evidence and objections and responses in terms of these are acquirable skills. Oftentimes you folks talk about trial advocacy, oh, this person's good at trial advocacy. Oh, trial advocacy comes natural to them, or they're a natural presenter. Well, as it relates to the rules of evidence and how they play out in court, this is acquirable. This is something you can work on, you can get better at, and you can exercise and practice and really get to be a trial skill. There are people that are practicing, that are trying cases all the time, that don't have this as part of their arsenal. They said, oh, I'll figure out the rule when it comes up, or I'll look it up if it ever applies in a case. But it can really be an acquirable trial skill that you have. The other thing that's readily apparent from some of these people that are practicing that haven't taken this on board is that you cannot fake your way around evidence oftentimes. You can't fake responses. You can't fake just offering up the judge something when an evidentiary objection comes out. You actually have to know these rules. You actually have to know the best responses. And you have to keep on that appearance that you are doing your job in front of a jury. When you fake it, it looks bad. So again, this is that environment where the jurors are watching you, and they're watching what you're doing, and I want you to take it as an opportunity. And here's what I want you to think about the opportunity is. It's an opportunity to show that you know these rules. Again, if you're in that upper deck of a medical facility and you're watching some kind of procedure and you're watching some kind of surgery and you're watching the doctor's work, there's certain things you're going to look at and you're going to key off of. Look at how the way they communicate. Look at the way they actually work with the tools and replace one at a time. Look at the way they use the light. You're going to pay attention to the way they operate. This is one of our tools. The rules of evidence are one of our tools in trial. The jury, even if they don't know what hearsay is, or they don't know what you meant by something lacks authentication, or they don't understand your response that an exception applies to that rule, they know whether you have command over it or not. It's also an opportunity to show that you've prepared. I think about these things, and we're going to talk about it as we talk about something called evidentiary censors. I've prepared my case. I've not only prepared what witnesses I'm going to call and the questions I'm going to ask to those witnesses. I've not only prepared how I'm going to incorporate exhibits and physical evidence throughout the trial, but I've prepared in a proofreading sense. If I'm going to send a letter out or I've written a memo and I want to proofread, I'm going to look for typos and sentence construction. If I'm going to proofread my trial preparation, if I'm going to proofread my witness examinations, I should be looking for and proofreading for objections and potential objections that could come from my opponent. And I should be looking at that first stage to say, okay, this is a possible objection here. I'm clearly asking this witness for a statement, and a statement that is out of court offered by some out of court declarant. That could, I have to recognize, that could bring a hearsay objection. So what I can do is I can show my preparation. I have a response for it. I may have laid foundation in the previous questions to help me out in that response. And the jury can see that if I ask questions in a certain way, objection, hearsay, Your Honor, we've already asked questions that establish that an exception applies. This is an excited utterance under 8032. And I offer my response that shows in a way that I prepared. The objection then presents an opportunity for me to demonstrate that I'm prepared. And the last one is your skill and poise. As difficult it is and as traumatic as it is for you as law students and for new lawyers to deal with this balls in the air. I'm asking questions of a witness, I'm getting different answers, I'm told to listen to the witness's answers. I'm also supposed to maintain my presentation skills in front of the jury. And now I have an objection for which I have to respond, and it turns into a juggling act. Well, when you handle it, and you handle it with poise, and you respond to an objection, reflect that you know the rules, reflect that you have prepared, objection, response, objection overruled, and you return seamlessly to the question you were asking before, you've just showed the jury something. You've showed the jury something about your preparation, but you've also showed the jury that you've anticipated this and you can handle it. And if this is my courtroom and I am supposed to have command over this space, I can show and I can seize on this opportunity of objections to hold off the objections with my right hand and keep up my activity of questions and answers to a witness or putting in a document with my left hand. So think of it as an opportunity as we go forward. And remember that these stage lights are on.